The Supreme Court has just delivered a stunning 9-0 ruling. And whether you support the Second Amendment or simply follow major constitutional cases, this one is impossible to ignore. Overnight, without any warning, without any signals in the prior oral arguments, the court issued one of the most unexpected and far-reaching decisions we've seen in years. And what is happening right now within hours of the decision is something nobody was prepared for. States are scrambling. Federal attorneys are repositioning. Gun rights organizations are already drafting emergency responses. And millions of Americans are waking up this morning wondering how this ruling will reshape the future of the Second Amendment in ways no one predicted just a few months ago. A 9-0 ruling on a high-stakes 2A-related issue is almost unheard of. The court is usually divided, often 5-4 or 6-3, on firearms. To get all 9 justices, conservative, moderate, and the most progressive wings aligned on one single conclusion means something very unusual just happened. This was not a normal case. This was not a normal ruling, and this was not a routine interpretation of past precedent. This was the court laying down a unanimous, unavoidable position that directly affects how states can regulate, restrict, or attempt to control firearm-related conduct going forward. And within minutes of the ruling dropping, states were already reacting, some with panic, some with anger, and some treating it as an unexpected legal gift. Because this ruling in practice wipes out the foundation a number of states were depending on for their pending regulations, lawsuits, and enforcement strategies. Overnight, entire legal arguments that states have been using for years are now gone. And for many of these states, there is no backup argument, no alternative justification, no fallback position. This decision didn't just close a door, it slammed it shut, locked it, and welded it from the outside. Now, here's the first thing everyone needs to understand, and this is something the media is already misreporting. The court did not suddenly expand gun rights beyond what Breen or Heller established. Instead, what the court did was much more dramatic in a different way. It tightened the rules around how states can attempt to sidestep constitutional protections, because that's exactly what this case exposed. States quietly building loopholes, workarounds, or indirect restrictions designed to function like gun bans while not technically being labeled as gun bans. This ruling effectively says you cannot disguise restrictions, you cannot reabel them. You cannot transfer them from one agency to another. If the effect is unconstitutional, the mechanism doesn't matter. And that right there is why this ruling sent such a shockwave across the country. Gun control states were hoping the Supreme Court would ignore the structural games being played in their legislative language, things like adding non-fire penalties to firearm-related conduct, things like shifting enforcement from police to administrative boards to avoid constitutional scrutiny, things like redefining possession as public risk behavior to claim they were regulating conduct instead of firearms. But the court saw through it unanimously. The next piece of this that people need to understand is how this ruling immediately affects ongoing litigation across the country. Multiple lawsuits are in active stages over assault weapon bans, magazine bans, tax-based restrictions, purchase permits, carry restrictions, and exotic new enforcement mechanisms created by blue states trying to insulate their laws from brewing. This ruling gives gun rights plaintiffs an entirely new weapon in their legal arsenal, something they have never had before. A unanimous statement from the court that indirect restrictions are treated the same as direct ones. When the court said that the Constitution cannot be avoided by administrative structuring, they basically destroyed the primary strategy gun control states have been using since 2022. Regulatory rerouting, moving enforcement away from law enforcement agencies and into licensing boards, advisory commissions, or liability-based penalties. All of that is now constitutionally irrelevant. If the underlying effect burdens core 2A rights, the mechanism doesn't matter. That alone changes how dozens of pending cases will be litigated in the coming months. But let's step deeper into the ruling, because the part that shocked legal analysts was not just the conclusion, it was how strongly worded the opinion was. For a court that is normally careful about language, normally cautious about signaling future legal interpretations, this ruling read like a clear warning shot, almost a blueprint for the cases coming next. The court did not say, "We disagree with the state's approach." They said the state's actions were an unconstitutional circumvention of constitutional protections. That phrase is going to appear in lawsuits nationwide. The opinion also stated that no branch of government, federal or state, is allowed to restructure enforcement in a manner designed to escape constitutional review. This is the first time the Supreme Court has used wording this explicit in a modern 2A context, and it signals very clearly that the court is watching states that attempt to engineer around the Second Amendment instead of confronting it. Honestly, the ripple effect is enormous because now states like California, New York, Illinois, New Jersey, and Maryland, states that rely heavily on complex regulatory frameworks instead of straightforward bans, are going to face immediate challenges. Their attorneys general are already in emergency meetings this morning. They know what's coming. Their entire legal justification for dozens of firearm-related statutes was based on exploiting the gray areas around enforcement structure, not the substance of the restriction itself. Those gray areas are gone. The federal government, meanwhile, is in a different position. While this case does not directly attack federal agencies, it does indirectly challenge one of their favorite tools, administrative delegation. Agencies like ATF have depended heavily on being able to shift interpretations, redefine categories, and create indirect penalties through regulatory definitions rather than explicit congressional lawmaking. While this decision does not overturn any specific ATF rule, it signals very bluntly that the court is prepared to treat indirect restrictions as constitutionally equivalent to direct ones. That should worry federal agencies, especially given how many lawsuits the ATF is already facing over frames and receivers, pistol braces, private sales rules, and NFA-based administrative interpretations, because here is the larger takeaway of the ruling. If a state or federal agency creates a system where the effect is the same as a gun ban, but the structure is designed to hide that fact, it's now unconstitutional. The court is clearly setting boundaries for how the Second Amendment will be treated going into 2025 and 2026. They are laying down a legal architecture that will influence the next decade of 2A cases, and they are doing it unanimously. But the most shocking part of this ruling may not be what they decided, it's what they hinted at. In multiple paragraphs, the court referenced the need for consistent historical grounding and warned against modern constructs designed to bypass constitutional limitations. These phrases echo Bruin, but they go a step further. They suggest the court is preparing to expand the historical test requirement deeper into enforcement mechanisms, not just into the law itself. That means this ruling is not the final blow. It's the opening shot for what the court is going to do next. Now let's talk about the immediate fallout happening across the country. The ruling has created a domino effect. Gun rights organizations are already filing emergency motions citing the new opinion. States are being pressured to freeze enforcement of certain regulations until they can determine whether their enforcement structures will survive scrutiny. County sheriffs in multiple states are publicly stating they will not enforce rules that now appear constitutionally vulnerable. For example, in states with permit-o-purchase laws, officials are questioning whether denying permits through administrative discretion rather than explicit statute will now violate the ruling. In states with complex carry restriction maps, officials are reviewing whether their zoning-based permit systems constitute indirect infringements. And in states with aggressive licensing boards, legal analysts are warning that discretionary penalties or administrative risk classifications may now be unconstitutional. This is the first time in years that a single ruling has triggered this much uncertainty this quickly. Meanwhile, in the political arena, the reaction has been equally intense. Some lawmakers are calling for emergency legislative sessions to rewrite statutes. Others are warning that the ruling may be used to dismantle long-standing regulatory mechanisms. And gun control activists are expressing alarm that their workaround strategies may have been eliminated entirely. On the other side, gun rights advocates see this as a once-in-a-generation victory. They believe the unanimous vote, especially the inclusion of the court's 3 liberal justices, signals that the court is no longer willing to tolerate creative regulatory circumvention. They believe this ruling gives them a clear path to challenge a broad range of laws previously considered untouchable, and they're probably right. But here's where things get even more intense. Multiple major 2A cases are already headed for the Supreme Court. They were expected to be decided next term, but now analysts are wondering whether this new ruling will accelerate some of those cases or even influence how the court chooses which ones to hear. Because if the court just sent a nationwide message unanimously about the limits of indirect firearm regulation, then the cases coming next are the ones dealing with direct regulation. Assault weapon bans, magazine bans, age-based restrictions, purchase permit requirements, and discretionary carry limitations. This ruling sets the tone for all of them. The court is making it clear that they are focused on constitutional structure, not just statutory language, and that is why what happens next truly will change everything. States cannot simply rewrite wording, rename enforcement boards, or create new safety classifications and expect the court to ignore the manipulations. For the first time in decades, there is a bright line. The Second Amendment cannot be eroded by structural design. The next 12 months are going to redefine the national landscape of firearm law. This ruling is the flashpoint, the first domino, the case that will be cited in countless lawsuits across the country, and it will force states, federal agencies, attorneys, and judges to confront the Second Amendment honestly without the legal smoke and mirrors that have dominated the debate for years. This was not just another Supreme Court decision. This was the court stepping in and saying, "We see what you're doing, and it stops now." And that's why everything from this point forward, every appeal, every injunction request, every legislative attempt will be shaped by what the court just handed down: a unanimous ruling, a nationwide shockwave, and a legal shift that will be felt for years to